Your property is in violation. You have 14 days to comply, or we will take action." She said it the way people say things they have rehearsed, with a flatness meant to sound like authority, the words arriving in a sequence so practiced that the spaces between them had been timed. She was standing at the edge of my gravel drive, in a blazer the color of slate, a clipboard pressed to her chest, and she had no idea that the ground beneath her feet, the access road she had driven in on, the parking lot her board had paved 2 summers ago, all of it sat on land I owned. I held the deed. I had held it for 11 years, and before me my father held it. And before my father, his father Elias had held it in a county records office in Harlan County, Kentucky, in the spring of 1938. I had not sold it. I had not ceded it. I had simply never been asked. Drop a comment. Tell me where you're from, and if something like this has ever happened to you, I want to hear it. The morning she showed up, the ground was still cold from an overnight frost. The old black walnut at the edge of the south field was bare and dark against a white sky, and the air smelled of iron and wet clay, the way this land always smells in early March. I had been walking the fence line. That was where she found me. My name is Calhoun Marsh. I am 61 years old. I have lived on this land, or land connected to it, for the entirety of my life, and for most of that life I understood the land the way you understand something that has always been beneath you, as a given, as a constant, as a thing that simply is. It was only when someone tried to take it that I began to understand it as something I had to defend. The parcel sits in the hill country of eastern Tennessee, just over 240 acres that my grandfather Elias Marsh acquired in 1938 through purchase, labor trade, and a single recorded warranty deed naming him sole grantee. Elias had come from eastern Kentucky with his wife Nora and their 2 children, my father Clarence among them, carrying little except a reputation for honest work and an almost architectural patience. He spent the first 3 years clearing timber from the western quarter, selling it through a mill in Crossville, and with those proceeds paid off the purchase note in full. The deed was recorded in Book 14, page 312 of the Overton County Register of Deeds. I have a photocopy framed in my office. The original sits in a fireproof box in my closet, inside a manila envelope that also holds the 1952 survey, the 1971 boundary revision, and every property tax receipt my family has paid since Eisenhower was president. Elias had done one other thing on that land that matters to this story. In the northeast corner of the property, on a gentle slope above a creek feeding into the Cumberland River watershed, he set aside a 1/4-acre plot and fenced it with split cedar rails. He buried his mother there in 1941, then his father-in-law in 1944, then Nora herself in 1967. Over the decades that followed, the plot grew to hold 11 graves, 3 generations of Marshes, including my father Clarence, buried there on a cold October morning in 2004, and my mother Ruth, who followed him in 2009. The plot was registered with the county as a private family cemetery under Tennessee Code Annotated Section 46-2-101. I had renewed that registration myself in 2011. The cedar fence was still standing. The iron gate my grandfather had hung was still on its hinges. My cousin Adeline drove out from Cookville twice a year to tend the flowers. I had always known the cemetery was there. I had always known it was mine. What I had not fully accounted for was the growth of Clearwater Ridge Estates, the residential development built along the western edge of my property line beginning in the late 1990s. I had sold a strip of land, 40 acres along the western boundary, to a developer named Caldwell in 1997. That sale had been clean, properly surveyed, and recorded. The development went up, the HOA formed, and for many years the arrangement was unremarkable. My remaining 200 acres sat behind the development, accessible by an easement road I had retained in the sale agreement. The HOA managed its streets and common areas. I managed mine. The 2 worlds did not overlap, or so I believed. The first letter arrived on a Tuesday in late February by certified mail, which I noted because ordinary correspondence does not arrive certified. The return address was Clearwater Ridge Estates Homeowners Association, and the name beneath it was Patricia Voss, Director of Community Standards. I signed for it at the mailbox, brought it inside, set it on the kitchen table, and made a cup of coffee before I opened it. The letter was 2 pages. The first was a formal notice of violation citing unauthorized encroachment on HOA-managed common area and failure to maintain community aesthetic standards. The second page listed specific violations, and it was item 3 that stopped me. It called for removal of an unauthorized structure within the community's northeast common area, specifically a deteriorating wooden enclosure at coordinates that, when I looked them up on the county assessor's parcel map, placed them precisely on the quarter-acre plot where my family was buried. I read item 3 twice, then a third time. I was not angry. I want to be clear about that. What I felt was something closer to a very specific kind of attention, the kind that arrives when you realize a situation is more serious than it first appeared. I set the letter beside my coffee cup and looked out the kitchen window at the walnut tree. Then I drove to the county assessor's office. Patricia Voss arrived at my property the following Thursday in a white SUV with the Clearwater Ridge Estates logo on the door panel. She was perhaps 50, with the manner of someone who had spent a long time being listened to and had come to expect it as a matter of course. She wore the slate blazer. She carried the clipboard. She introduced herself with her full title and told me, without warmth, that the HOA had received a complaint about the condition of the northeast common area. I asked which resident had complained. She said that was confidential. I said that was fine, and asked her to show me specifically which parcel the HOA considered its northeast common area. She turned the clipboard toward me. The map was a printed satellite image with a hand-drawn boundary overlay in red marker, and the boundary included the cemetery plot. It also included approximately 3 acres I knew, from the 1952 survey and the 1971 revision, and every tax receipt in my fireproof box, to be mine. I looked at the map. I looked at her. I said, "I see." She took that as agreement. She told me the HOA would send a crew to clear the enclosure within 30 days if I did not do so myself, that the wooden structure was a safety liability and an aesthetic violation, and that the HOA had a responsibility to maintain its common areas in good order. She said all of this with the calm certainty of someone who had never been wrong before, or at least had never been told she was. I thanked her for coming out. I watched her drive back down the access road. Then I went inside and called my attorney. His name was Warren Aldecoa. He had handled property matters in Overton County for 30 years, with the particular quality of a man who has read more deeds than novels, a deep, unhurried familiarity with the way things are actually recorded, as opposed to the way people believe they are. I had used him once before, when a utility company tried to expand an easement beyond its recorded width, and he had resolved that in 11 days with 2 letters and a plat map. I trusted him the way you trust a tool that has never failed. I told him everything: the letter, the map with the red marker boundary, the cemetery. Warren was quiet for a moment. Then he said, "Send me everything you have." I sent him the deed, both surveys, the tax receipts, the cemetery registration, a photograph of the iron gate and cedar fence with the graves visible behind it, and a copy of the HOA's letter and satellite map. He called me back the following morning. His voice had a quality I had not heard before, not alarm exactly, but something adjacent to it, careful in a way that suggested he was choosing his words with unusual precision. "Calhoun," he said, "I need you to understand what they appear to have done. Based on the coordinates in the HOA letter and the parcel map he had pulled from the county assessor's database, the area the HOA was claiming as its northeast common area was not part of the 40 acres I had sold to Caldwell in 1997. It had never been transferred. It had never been included in any HOA declaration or plat. The HOA's claim had no recorded legal foundation. None. And then he told me the other part. The parking lot the HOA had paved the previous summer, the one Patricia Voss had driven across to reach my driveway, was not on HOA land either. According to county parcel records, It sat on a strip of my property between the formal boundary of the Caldwell sale and the edge of the cemetery plot. Someone had simply assumed it was common area and paved it. And beneath that asphalt, according to the registration records and the coordinates Warren had cross-referenced, were 2 of the 11 graves. I sat with that information for a long time. Warren said, "I think we need to talk about more than a property dispute." He was right. What had begun as a letter about a fence had become something else entirely. It had become a question about what had been destroyed and when and by whose decision, and whether anyone had checked the records before sending a paving crew onto land they did not own to cover ground the state of Tennessee had recognized, in writing, as a protected private burial site. The answer was no. No one had checked. Patricia Voss had not checked. The board had not checked. The contractor had not checked. They had looked at a hand-drawn map on a clipboard, assumed the land was theirs, and proceeded as if assumption and ownership were the same thing. They are not the same thing. Warren filed a formal title dispute with the Overton County Chancery Court on the 14th day after the HOA's deadline. The filing cited the original 1938 warranty deed, the 1997 sale agreement with its precise metes and bounds description, both surveys, and the cemetery registration under Tennessee Code annotated Section 46-2-101. It also cited Tennessee Code annotated Section 46-2-102, which makes it a criminal offense to knowingly disturb, destroy, or desecrate a registered private burial ground. Warren attached the county parcel map, the coordinates from the HOA's own letter, and a photograph of the parking lot with a red overlay showing the recorded cemetery boundary beneath it. He filed with the county register, with the Tennessee State Historic Preservation Office, and with the Overton County District Attorney's Office. I had not asked him to file with the DA. That was his judgment. I did not object. The response came 11 days later, not from Patricia Voss, but from a law firm in Cookeville the HOA had retained on short notice. The letter was 4 pages, written in the dense, slightly aggressive register of attorneys who believe volume and confidence are interchangeable. It disputed my ownership of the corridor parcel on grounds of adverse possession, arguing that more than 2 years of maintenance and improvement constituted a claim. It did not address the cemetery registration. It did not address Section 46-2-102. It did not explain how the HOA had come to believe the land was theirs. Warren read it and called me that evening. He said, "They've just told us they knew they were on your land and kept going anyway." An adverse possession claim, however weak, required the claimant to acknowledge that the land belonged to someone else. By raising it, the HOA's own attorneys had conceded the land was mine. They had simply argued that 2 years of parking lot maintenance had transferred ownership. Under Tennessee law, adverse possession requires 15 years of open, continuous, hostile, and exclusive possession. They had been there for 2. He said, "That's not adverse possession, that's trespassing." My neighbor Dale Hutchins had been watching all of this from across the county road. Dale was 73, had farmed the adjacent parcel since before I was born, and had a particular gift for noticing things without appearing to notice them. He had watched the paving crew work the previous summer. He had taken photographs from his fence line because, as he put it didn't look right to me. He had not known about the cemetery at the time. But he had the photographs, time-stamped, showing the crew working inside my boundary on a day I had not been present. He brought them to me in a manila envelope one morning, set them on the kitchen table beside my coffee cup, and said, "I figured you might need these." I thanked him. I added the envelope to the file. Warren had commissioned a licensed survey of the corridor parcel, not a desktop review, but a full boundary survey conducted on the ground by a registered land surveyor named Gerald Pratt, who had been working Overton County for 26 years and whose reports had the quality of sworn testimony. Gerald Pratt walked the line on a Tuesday in late March, when the ground was soft enough to take stakes and the creek ran high enough to confirm the drainage boundary the 1952 survey had used as its eastern reference. He spent 8 hours on the property and drove 43 stakes. When he compiled his report, he found something Warren described with the careful phrasing of a man who understood its significance completely. The HOA's parking lot encroached on my land by 61 feet at its deepest point. The hand-drawn red marker boundary Patricia Voss had shown me was not an approximation or an honest mistake born of ambiguous records. It was simply wrong in a way that no reasonable reading of the recorded plat could have produced. Gerald Pratt's survey showed that the true boundary ran along a ridge of exposed limestone visible from the road, noted in both the 1952 and 1971 surveys, identifiable in an afternoon by anyone who looked at the county's own parcel maps. Warren said, "Someone either didn't look or looked and decided not to care." I printed the survey report on my kitchen table, spreading its pages beside the 1952 document and the 1971 revision, and spent an hour with a ruler and a yellow highlighter tracing the boundary lines across all three. They agreed with each other in every particular. They all agreed against the HOA's claim. I set the highlighter down and looked out the window at the walnut tree, which had begun to show the first pale green of new leaves, and I thought about Elias Marsh standing on that same ridge of limestone in the autumn of 1938, understanding in the way that practical men understand things that the land was his because he had paid for it, recorded it, and it said so in the book. I added Gerald Pratt's survey to the file. The file now occupied a full banker's box, organized by date and category with labeled dividers, the deed and its chain of title in front, the surveys behind it, the tax receipts behind those, the cemetery registration and its renewal, the HOA's original letter and satellite map, the Cookville firm's 4-page response, Dale Hutchins's photographs, Gerald Pratt's survey report, Warren's court correspondence, and at Warren's suggestion, a written log of every interaction with Patricia Voss or any HOA representative, dates, times, and the words spoken, without interpretation, without feeling, just the record. Warren had told me early on that a well-kept file was not a passive thing. It was a form of argument assembled in advance, one that spoke before you did. I had taken that seriously. The Tennessee State Historic Preservation Office responded in the 4th week of April. Their letter was addressed to both Warren and the District Attorney's Office, written in the measured language of a state agency that has found something it did not expect. The office had reviewed the cemetery registration, cross-referenced the registered coordinates against the county parcel records, and confirmed that the registered cemetery boundary overlapped with the parking lot's footprint by approximately 420 square feet. They had also reviewed the paving contractor's work order, obtained through a public records request, listing the work date as the previous July. The letter stated that the office had determined there was probable cause to believe a violation of Tennessee Code Annotated Section 46-2-102 had occurred. That section, in the relevant part, reads as follows: "It is unlawful for any person to knowingly disturb, destroy, remove, vandalize, or desecrate any part of a human burial site, or to knowingly use any burial site for any purpose inconsistent with its use as a burial site, without the written consent of the legal owner and the next of kin of any person interred therein." The office had forwarded its findings to the district attorney and placed a formal hold on any further development or alteration of the identified area. I read that letter 3 times. Then I set it down and sat very still, listening to the silence of the house. Outside, a pair of mallards had come up from the creek and were working along the edge of the south field, moving through the wet grass with the unhurried industry of creatures who understood that the land was simply there, and that it was theirs to use, and that no one had told them otherwise. I thought about my father Clarence, buried on that hillside in October of 2004. I thought about my mother Ruth, who had stood at that iron gate every spring with a bundle of daylilies cut from the garden. I thought about Elias, who had fenced that 1/4 acre with split cedar rails and understood, in the way a man who has earned something understands it, that the ground he had set aside was not a common area. I was not angry. I want to be clear about that. What I felt was something closer to a cold and absolute certainty that the record was going to speak, and that when it did, it was going to be very loud. Warren called the following morning. The district attorney's office had opened a formal investigation. Gerald Pratt had been contacted for a sworn affidavit. The HOA's Cookville attorneys had already been in contact with the DA's office, and the tone of those conversations, as relayed to Warren, suggested the board was beginning to understand the nature of what they had walked into. The primary issue was no longer adverse possession. It was whether the board of Clearwater Ridge Estates had authorized the paving of a registered private burial site on land they did not own, and whether that authorization constituted a knowing violation of state law. Warren had obtained, through the same public record search that produced the work order, the contractor's written request for authorization, which specifically noted the proximity to boundary markers, and the board's written response. The board had provided the authorization in writing. It was signed by 3 members, including Patricia Voss in her capacity as Director of Community Standards. It was dated 4 days before the paving crew arrived. Warren said they signed it, they put their names on it, and the contractor's request specifically noted the proximity to the boundary markers. I said, I see. He said, Calhoun, I think you should prepare yourself for this to go somewhere you may not have anticipated when you first called me. I told him I had anticipated quite a lot by that point. I told him to continue and that I would continue keeping the file. He said, the file is going to matter more than anything else in this case. I already knew that. I had known it since the morning I sat at the kitchen table with the HOA's first letter and a cup of coffee, and understood that the ground beneath the question was not ambiguous. The ground was recorded. The ground was surveyed. The ground was mine. The banker's box had grown to 2 boxes by the time the district attorney's office issued its first formal communication to the HOA board. I had added a second set of labeled dividers, a supplementary log with certified mail tracking numbers, and a printed copy of the HOA's own governing documents, which Warren had obtained from the county register. Those documents contained, in Article 4, Section 7, a clause stating that the board was prohibited from making any claim to or improvement of land outside the recorded plat of Clearwater Ridge Estates without the written consent of the affected landowner. The board's own governing documents had told them not to do what they had done. I thought about that clause for a long time. I thought about the way institutions accumulate authority not through legitimate power, but through the assumption that no one will check. Patricia Voss had arrived at my fence line with a clipboard and a rehearsed sentence and the absolute confidence of someone who had never been asked to show her work. The board had signed an authorization because they believed the land was theirs, not because they had verified it. The Cookeville attorneys had raised adverse possession not because the law supported it, but because it was the only argument available to a client who had no deed, no survey, and no recorded claim. None of them had checked the record first. The record had been there since 1938. Book 14, page 312. It had been there through every administration since. It had been there when the development went up, when the paving crew arrived in July, patient and permanent and utterly indifferent to anyone's assumptions, waiting for someone to ask it a question. I had asked it a question, and it had answered. The district attorney's office issued its communication on a Wednesday morning in early May. It was addressed to Patricia Voss, to the 2 other board members who had signed the contractor authorization, and to the HOA's Cookeville attorneys. Warren received a copy as attorney of record. He called me that afternoon and read me the relevant passage. The office had determined sufficient evidence to support charges under Tennessee Code Annotated Section 46-2-102 against the 3 individuals who had signed the written authorization. Criminal desecration of a burial site, a Class E felony. 3 counts each, 1 for each grave Gerald Pratt's survey had confirmed lay within the parking lot's footprint. The office had also referred the matter to the county building inspector for review of the construction permits, which had been issued without a required boundary survey. Warrants had been issued. I sat with that for a long time. I did not feel satisfaction, exactly. I felt something more like the quiet that follows a long piece of work completed. The kind of quiet that has weight to it, that settles into a room the way cold settles into the ground in early March, slowly and completely until you can feel it in everything you touch. Outside, the walnut tree was fully leafed. The mallards were back on the creek. The land was the same land it had always been, patient and recorded and mine. The Chancery Court hearing was scheduled for the 2nd Tuesday in June. Warren told me to arrive early and to bring the boxes. I brought both of them, carried them in from the truck myself, and set them on the plaintiff's table in a courtroom that smelled of old wood and the particular dry stillness of a room where consequential things have been decided for a long time. The courtroom was small, as rural Tennessee courtrooms tend to be, a single gallery with wooden pews, a raised bench, a flag in the corner faded at its edges from years of morning light through the east window. I had been in this room once before when my father filed a boundary clarification in 1989, and sitting down at that table I had the sense that the room remembered the name. Warren arrived 12 minutes after I did, carrying his briefcase and a rolled survey document. He looked at my 2 boxes and said, "Good." That was all. The HOA's Cookeville attorneys arrived shortly after, 2 of them, younger than I had expected, carrying the slightly pressed look of people who have spent weeks reviewing documents they wished they had never seen. They sat up at the defense table without making eye contact. Patricia Voss was not present. Her attorney had advised her, under the circumstances of the parallel criminal proceedings, not to attend. Warren presented the case in the order he had assembled it over the preceding months. He started with the deed. He placed a certified copy of Book 14, page 312, before the court, and read the relevant language aloud in the steady, unhurried voice of a man who has read a particular sentence many times and knows exactly what it means. He moved through the 1997 sale agreement and its metes and bounds description, the 1952 survey, and the 1971 revision. He presented Gerald Pratt's current survey and Gerald Pratt himself, who had driven up that morning and took the stand with the quiet authority of a man whose measurements are never wrong because he does not allow them to be. Gerald Pratt testified for 40 minutes. He used the rolled survey document and a pointer. He showed the court, in the precise geometric language of registered land surveying, exactly where my boundary was, exactly where the HOA's parking lot was, and exactly how far one extended into the other, 61 feet at its deepest point. He said it the way a doctor reads a number from a chart, without drama, because the number itself is sufficient. Warren then presented the cemetery registration, its 2011 renewal, the State Historic Preservation Office's April letter confirming the overlap, the contractor's work order, the contractor's written request for authorization noting the proximity to boundary markers, and the board's written authorization in response, signed by Patricia Voss and 2 other board members whose names I had read so many times by then that I knew them the way you know the names of people who have made a permanent impression on your life, though not the impression they intended. The HOA's attorneys had abandoned the adverse possession argument entirely. In its place, they offered mutual mistake, that both parties had been operating under a misapprehension of the boundary, that the HOA had acted in good faith, and that the appropriate remedy was a negotiated adjustment rather than a judicial ruling. They said this with the controlled delivery of attorneys who know they are losing but have a professional obligation to present the best available argument. I did not fault them for trying. It was the only argument left. Warren addressed the mutual mistake theory in approximately 4 minutes. The boundary was not ambiguous. The 1952 survey, the 1971 revision, and the county's own parcel maps all agreed with each other and with Gerald Pratt's current survey. The HOA's own governing documents, specifically Article 4, Section 7, explicitly prohibited the board from making any claim to or improvement of land outside the recorded plat without written consent of the affected landowner. No such consent had ever been sought. The contractor had flagged the boundary proximity in writing before work began, and the board had signed the authorization anyway. He said, "This is not mutual mistake. This is unilateral disregard of the record." The chancellor was quiet for a moment. Then he asked the HOA's attorneys whether they had any evidence the boundary had ever been in dispute prior to the HOA's own actions. They said they did not. He asked whether they had any recorded instrument showing HOA ownership or claim to the corridor parcel. They said they did not. He asked whether the board had obtained a survey before authorizing the paving work. They said they had not. He said, "Then I don't see a dispute about the boundary. I see a boundary." He ruled from the bench. The ruling was clean and without qualification. The corridor parcel, including the full extent of the parking lot, was confirmed as my property pursuant to the original 1938 warranty deed and its recorded chain of title. The HOA's claim was without legal foundation and was dismissed. The parking lot was declared an unlawful encroachment. The court ordered the HOA to remove it at its own expense within 90 days and restore the surface to a condition consistent with the registered use of the land as a private burial site. The court also awarded attorney's fees under Tennessee's frivolous litigation statute on the grounds that the HOA had continued to press a claim after being put on notice through Warren's initial filing that the claim had no recorded basis. The HOA's attorneys wrote something down. They did not look up. I sat very still for a moment. I looked at the two boxes on the table in front of me, and I thought about all the mornings I had spent at my kitchen table adding to them, and about the walnut tree outside the window, and about my father Clarence, and I felt something settle in my chest that had been unsettled for a long time. Then Warren leaned over and said quietly, "Now, the other part." The arrests did not happen in the courtroom. They happened the following morning, on a Wednesday, in the ordinary procedural way that such things happen when a district attorney's office has completed its investigation and determined that the record supports criminal charges. The Overton County Sheriff's Office served the warrants at 7:15 in the morning. Patricia Voss was taken into custody at her home. The two other board members who had signed the contractor authorization, Gareth Poole, the HOA treasurer, and Diane Sutter, the board's vice president, were served at their respective residences within the hour. All three were transported to the county jail, processed, and released on their own recognizance by mid-morning pending arraignment. The charges were criminal desecration of a burial site under Tennessee Code, annotated Section 46-2-102, a Class E felony. 3 counts each, 1 for each grave confirmed within the parking lot's footprint. The district attorney had also added criminal trespass under Tennessee Code annotated Section 39-14-405, based on the unauthorized use of my land for the duration of the parking lot's existence. I was not present for any of it. Warren had advised me not to be, and I had agreed without argument. I was at my property that morning, walking the fence line in the early light, the way I had been walking it the morning Patricia Voss arrived in her slate blazer with her clipboard and her rehearsed sentence. The air smelled of iron and wet clay and the particular green smell of June, which is different from March in the way that all living things are different when they have been given time and water and the ordinary passage of days. I walked to the northeast corner of the property. I walked up the slope to the cedar fence and the iron gate. I stood there for a while, looking at the graves, at the gate that Elias had hung, at the split cedar rails that had been standing since before I was born. The morning light came in low across the hillside and caught the dew on the grass, and everything was very still and very quiet and entirely mine. The Chancery Court's order was entered into the record on the 22nd of June. The title to the corridor parcel was quieted in my name, unambiguous and uncontested, recorded in the county register as a supplemental instrument to Book 14, page 312. The board, what remained of it after the resignations that followed the arrests, voted at an emergency meeting to accept the court's order and begin removing the parking lot. They hired a different contractor. They obtained the required permits. They did the boundary survey first this time, before they did anything else. The removal took 11 days. I watched none of it. The land did not need me to watch it being returned to itself. Patricia Voss and Gareth Poole entered plea agreements in the fall. Diane Sutter went to a bench trial and was convicted on all counts. The sentences were suspended, conditioned on community service and the payment of restitution, calculated based on the cost of restoring the cemetery site and the legal fees I had incurred in establishing what the record had always said. The amount was not small. It was paid. The HOA was reorganized under new governance. 3 new board members were elected, and they hired a property management company with experience in boundary compliance. The first thing the new board did, according to Dale Hutchins, who continued to notice things, was commission a full survey of every inch of the Clearwater Ridge Estates plat. They wanted to know exactly where their land was. They wanted it in writing. I thought that was a reasonable place to start. The last time I walked to the cemetery that year, it was October, the same month my father had been buried there 19 years before. The removal crew had done clean work. The asphalt was gone. The ground had been graded and seeded, and the grass was coming in thin but steady, the way grass does when it has been given back to itself after a period of being covered. The cedar fence was intact. The iron gate was on its hinges. The graves were undisturbed, as the forensic review commissioned by the DA's office had confirmed. The parking lot had been laid over the surface without excavation, and the graves themselves, deep in the hillside, had not been touched. I stood at the gate for a long time. The walnut tree down the slope was turning, its leaves going gold at the edges the way they do in the second week of October, and the creek was running low and clear, the way it runs when the summer rains have ended and the fall has not yet begun in earnest. The mallards were gone south. The air was cold and clean and smelled of iron and wet clay and the first suggestion of wood smoke from somewhere across the hill. Everything was quiet. Everything was as it should be. There is a thing I have come to believe, having spent the better part of a year with 2 bankers' boxes and a very good attorney and a registered land surveyor named Gerald Pratt, and it is this. When an institution with apparent authority makes a claim against you, the first question you must ask is whether that claim has a legal foundation, not whether the institution seems confident. Not whether its representatives carry clipboards and drive vehicles with logos on the door. Not whether its letters arrive by certified mail with official titles printed beneath the return address. The question is whether the claim is grounded in the record, in the deed, in the survey, in the instrument that was filed, in the county register, on a specific day, in a specific book, on a specific page. That record existed before the institution. It will exist after it. It does not care about blazers or rehearsed sentences or hand-drawn boundaries in red marker. It simply sits in its book, patient and permanent, waiting for someone to ask it the right question. Ask the question. The answer is always in the record. If you have a story about land or a boundary or an institution that assumed authority it did not actually have, I would genuinely like to hear it in the comments. And if you want to be here for the next case, which involves a deeded easement, a locked gate, and a neighbor who decided the road belonged to him, subscribe and you will not miss it.